So Mr. Tyndall, why don't you come up? We'll take care of you.
Is it right if I stand right?
Yeah, you gotta stand at the podium anyway, you're fine. Okay. So this is in the matter of the people of the state of Michigan versus Skyshun Deshaun Tyndall. We have two files, 20-20027 FH and 22-20717 FC. So, Mr. Tyndall, we are here. So Becky, I'm not showing that I have any paperwork on file number 20-20027 in the file. Nothing's been filed in there since August.
Okay, I'll print it, Judge.
So there's a violation of probation on each file. It states that you failed to report on September 24th and October 1 of 2024, and that you failed to pay court-ordered costs and $198. So Ms. Holly, is that the balance on file number 22-20717 FC?
Yes, the other file is 1638.
1638?
Yes.
1638. All right.
I'm sorry, I don't mean to cut you off. What was that, 180 or we said 180 or 190?
198. So what Ms. Holly's saying is on file number 22-20717 FC, you paid off everything.
Yeah.
But $198.
Actually, he
And then
hasn't paid
on
anything.
Yeah.
Why does it say $198?
That's all he was
Everybody
ordered.
stop talking at one time. I asked Ms. Holly. Hold on. Ms. Holly.
That's all he's ordered in that file.
Oh, got it. And then on file number 20-20027 FH, the balance is 1638. Does that include the attorney fees?
I don't know if he had attorney fees. Let me look.
He had a PD on that file.
So yes, that would have 450 attorney fees.
Okay, so, all right, so that would take us down to like 1,200. All right, so Mr. Tyndall, do you understand those are the allegations on both your files?
Yes, ma'am.
Okay, on 20-20027 FH, you're currently on probation for a delivery manufacturer charge, which carries a maximum penalty of up to 20 years if you plead guilty or found guilty. Do you understand that?
Yes, ma'am.
And then on 22-20717 FH, you're on probation for felonious assault, which carries a maximum penalty of up to 4 years in prison. Do you understand that?
Yes, ma'am.
Now, Mr. Tyndall, you do have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
No, ma'am, I'm fine.
Are you sure?
This is a violation, and yes, ma'am, I'm here because I did what I did. Yes, ma'am.
Okay,
Yes, ma'am.
okay,
Yes, ma'am.
okay. So you understand it's no big deal. We'll appoint when there's no cost.
Yes, ma'am. I'm fine.
You want to proceed without an attorney?
I mean, I guess I get an attorney. Yes, ma'am.
Okay.
I get an attorney.
So you're in a lot of pain today, so I can set this over for another day.
That's fine. That's whatever best for you guys. I'm just ready to go.
Okay, because we got a busy morning and I wouldn't be able to see you until later today anyway, and you can't sit, so. All right, so what I'm gonna do is enter a plea of not guilty. We're going to assign a court-appointed attorney. You need to report to Ms. Holly.
Yes, ma'am. Yeah, I know. Yes, ma'am.
When is his next report date? Tuesday, Ms. Holly?
He was supposed to report yesterday and he didn't. I have not seen any medical documents.
So it's supposed to be for quarter.
Okay, well, he will get those to you. You got medical
I got
documents?
them right. I can show right now.
Okay, so I want you, before you leave today, I want you to go across the hall and let him make copies for Ms. Holly.
It's can I email it? I have my my ProMedica mic chart.
You know how to,
I have my mic chart or something like
yeah, do you know, can you print it off?
that. I can't email.
That's what he needs to do.
Well, he
I have
doesn't
a
have a
paper.
printer, nobody has.
Oh, I have a regular paper at home too with my medical thing also.
Do you have like your release paperwork?
Yes, that's at the house. but-
Okay, you need to bring that to Miss Holly Tuesday morning, Miss Holly.
Yes.
All right, Tuesday morning, you need to report to Miss Holly. You need to bring that paperwork so she can verify you were hospitalized, okay? And then Miss Adams, would tomorrow or Friday be okay to set this over to?
I'm sorry, I have to go get this removed tomorrow.
Don't show me. I don't want you showing me nothing.
I have to get it removed tomorrow morning.
I see it, but I don't want to see anymore. I had one of those,
Yeah.
kind of like a thing and like that, and it's awful. So next week?
That's fine, that's
All
fine.
right, Miss Adams, and you need, can you pay some of this off?
Yeah, I can. At first, I told her, when I was making.
No, I'm just a yes or no.
Yes, ma'am, yes, ma'am.
Okay, all right, so, okay, on,
I would say Wednesday's probably best, Judge, next week.
all right, so can I get a notice of hearing for him?
Yes.
So Miss, Holly, on file number 20-20027 FH, the balance owed will be 1188. And then, on the other paperwork, the balance will remain the same. Okay, and, we'll get you a notice of hearing. I'll enter a plea of not guilty.
Yes, ma'am.
Contact the public defender's office, not today, because it's crazy busy. We'll send the paperwork to Miss Underwood and just reach out to them this week, okay?
Thank you so much.
All right, so just hold on a minute. We'll get you a notice of hearing and then make sure you bring all that paperwork back to Miss Holly when you report on Tuesday, okay?
Yes, ma'am.
All right,
Thank
good. Thank you. Yep, so you can just stand there for a minute.
I was making payments. I was taking all my payments downstairs. I didn't know I had to make them upstairs. Yeah, so I was taking all my payments for my tickets and all my fines downstairs.
Yep,
Yeah.
they will do that. You gotta pay both. This will be October 30th. All right, and Miss Adams, you said I need to see the extradition. I need to,
This is the email message.
I know, I've got chats and emails and I get a little squirrel.
Thank you so much. This is all I need.
That's all you need.
Thank you, guys.
So don't forget, Tuesday morning, report to Miss Holly and bring her your release paperwork from the hospital so she knows what happened.
Okay, thank you so much.
All right, feel better. Thank you.
So, yeah.
Yeah, I think they have to, yeah, unless they agree not to. Okay, I'll call the jail. Hi, this is Judge Ancelone. I am ready for Devon Washington Jr. It's an extradition, and then he's gonna need his copies of the extradition paperwork with him. That he has to sign the waiver.
I have an envelope, which I assume is supposed to be preserved.
Yep, probably.
Yep, waiver of extradition papers.
All right, and I can see him whenever you're ready.
All right. All right, we'll get them up for you.
All right, thank you. Bye-bye. Good morning.
Judge,
Yeah,
are you coming off the bench?
no, yes, I can. What do you want me to do?
I don't know if Isaac has access to Jackie. I'm trying to get a hold of her to log in on that extradition.
Why do we need Jackie? Becky, will you let me out of the courtroom? Perhaps my first replacement to be here. With that, so. He said his baby can't be allowed. And I actually.
Is the same one. I believe you still need to sign all. So to go. I'll leave you in a minute. Just wait to sign that part.
Please rise. Is your court now session? Maybe see.
Okay. Good morning. I have a gentleman in the jail Zoom room. What's your name, sir?
Davon Washington.
Okay, so Mr. Sneed will, Miss, Chief Prosecutor Weiss is coming in, correct?
That's my understanding, Judge. Good morning.
Okay. All right, so just wait for a moment, Mr. Washington. Mower.
Judge, Ms. Weiss said she was in the waiting room.
Let's see, maybe she is. Oh, yeah, she is.
No more.
Hi, this is Judge Anselone. I am ready for Lewis Adams, Jonathan Maurer.
Ooh, all right, hold on. You're gonna give me a huge list. Give me a second here.
I'm actually ready for everybody.
Everybody.
Everybody that has my name next to them, I'm ready for.
And, all right.
Yep,
All right.
and we could start with Shoemate and someone else, but Shoemate too, to start with. All right,
Okay, that's good.
thank you, bye.
Just like,
All right, now we have Miss Weiss. All right, this is in the matter of the people of the state of Michigan versus Devon David Washington Jr., file number 24-2206-22016AX. I have Mr. Washington appearing via Zoom from the jail. This is a date and time set for an extradition hearing. We did receive paperwork from the state of Ohio on an extradition. This is rather unusual because I believe Ms. Weiss, the people at this time are objecting to extradition due to some pending charges, correct?
Correct. For two reasons. One, he has a bond here and pending charges. We don't want to lose jurisdiction over him. And two, this is an interstate compact case. He signed a pre-waiver. So even when he goes back to Ohio, I think Ms. Wilkerson is supervising for the state of Ohio. So
Okay. And you were gonna talk a little bit about how there has to be agreement between the states for extradition as well on the record?
That's correct, Your Honor. I didn't need to put that on the record, but yes, we are objecting to extradition and there needs to be an agreement between those states.
All right, so Mr. Washington, evidently you have some pending charges here. And because Ohio has requests for extradition, we'd like to take care of this stuff here first. So the people are objecting to you being extradited right now. But as soon as that's addressed, we'll proceed with the extradition to Ohio, okay?
Okay, they just wanted me to just talk to me about my probation because like she said, I got transferred over from Ohio. So only reason they wanted to talk to me is because I have a change of address needed to be made because I have a no contact at the address that I have on file.
So, sir, hold on a second. I don't want you to get into things that, because this is a court proceeding, anything you say could be used against you. So at this point, I'm not here on your VOP. I'm not here on any of that. So I don't want you to get into that information too much. Just know that as soon as we can, we'll bring you back on the extradition, okay? All right. Thank you, Mr. Washington. You have a good day.
Thank you.
Thank you. All right, so is anybody in here a defendant? You don't know? Are you a defendant? Do you have a court case today?
No.
What's your name?
Maybe.
Okay. Saw you here a minute ago. Mr. Malauer is your attorney. You want to come on up? Mr. Malauer, I have Ms. Turner and Mr. Mawad. You are here on, who are you here on?
Nick Williams, plea judge.
Okay,
With Isaac.
Right, he is not in my waiting room yet. So we will, it's not till 8, well, yeah, it's 8:30. Okay. So Ms. Turner, thank you. Let me grab your file. This is in the matter of the people of the state of Michigan versus Navy Justice Turner. File number 24-21849FH. I have Salvatore Malaro appearing on behalf of Ms. Turner, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference in this matter. Mr. Malaro, how would you like to proceed today?
Can you hear me?
Yeah.
All right. All right, Judge, I'm going to ask to adjourn this matter. I'm still in the investigation phase and tracking down some of the witnesses. There was a lot of commotion and witnesses in this case, and I would request the additional time.
All right. All right. So Ms. Adams, because Ms. Turner is here, could I get a notice of hearing? How far out are you asking for an adjournment, Mr. Malaro?
I think 30 days would be sufficient, Judge.
How about November 27 at 8:30 in the morning?
That would be fine, Your Honor.
So Ms. Turner, we're going to set this over to November 27 at 8:30 in the morning. I'm going to get you a notice of hearing today. So if you want to have a seat right behind you on that bench. No, right there. Yep. Yep. And we will see you back on that day. Okay. Make sure you stay in contact with Mr. Malaro. All right. I do have the plea as an attempted ag assault with HIDA, no upfront jail. Okay. All right, Mr. Rogers, let's see. Your attorney is Mr. Malaro. So I'll grab your file. This is in the matter of the people of the state of Michigan versus Scott Allen Rogers. We have two files, 24-21764FH and 24-21815FH. I have Salvatore Malaro appearing on behalf of Mr. Rogers. Mr. Rogers is zooming in from the Lenawee County Jail, and I have Isaac Sneed appearing on behalf of the people. this is the date and time set for a pretrial conference in this matter. Mr. Malaro, how would you like to proceed? Now I can't hear you. It works so well for that 1 minute. Go ahead again, Mr. Malaro.
Let's try this. There we go. Judge.
There we go.
May I have a breakout with Mr. Rogers very quickly? Shouldn't take long.
Yep, and we are set for trial on November 5. So, Mr. Rogers, I'm going to open up a breakout room. Give you an opportunity to speak with your attorney. So, let me see, we're in jail, Zoom 3. Go ahead and join that breakout room. All right, I have jail Zoom. Stephen, find out who this is. Right, and I have somebody in a dark shirt at the jail. What's your name, please?
Archie Prophet.
All right, I'm going to change your screen name just real quick because I will forget in 5 minutes if I don't keep track of it. It's 2 F's, right?
Yep. Yes,
Yep.
yes, ma'am. 2 T's.
Who's your attorney?
Murphy.
All right, so I had it down. Okay, and Stephen, I have a Stephen in a blue shirt. Looks like you're in a semi truck or something, but what's your name, please?
Stephen Clack.
Spell your last name.
CLACK.
All right, who's your attorney?
I don't have an attorney.
Okay.
This is for a child support hearing.
Well, are you supposed to be at the front of the court for a referee hearing?
No, we always do it by Zoom.
Right, but it's a Zoom hearing at front of the court, right?
Yes.
Okay, on your paperwork, there should be a different Zoom number for the referee. Don't read it out loud, but see if you can find it. So, Mr. Clack, I'm going to put you in a breakout room with my assistant real quick. And she's going to give you that number because you're not in front of me today. So,
I apologize. I grabbed the wrong paper.
Did you find it?
Yeah, I grabbed the one accidentally from last month.
Do you have the correct Zoom number now or you need it?
I still need it, Judge.
Okay, so Miss Adams, I'm going to pop you in a breakout room with him. Could you please give him the FOC referee Zoom number? All right, go ahead and join that breakout room, sir.
Oh, okay.
Thank you. All right, Mr. Mawani.
Did I already have it if you want to throw me in there?
It's already in the breakout room. I have the number, I just didn't want to put it on YouTube. All right, Mr. Malaro, we are back with Mr. Rogers. How would you like to proceed today on behalf of Mr. Rogers? No audio.
How about now?
All right, Miss McGrain, can you please contact IT and tell them, please do something about Mr. Malaro's microphone? All right.
How about now?
What would you like to, I can hear you now. What would you like to do with Mr. Rogers today?
Your Honor, I believe we have reached an agreement in a plea, and I'm just waiting for Mr. Sneed to send me the final details. So if we could pass on this for a few minutes.
Okay. All right. So Mr. Rogers, you're just going to hang out for a moment. All right. I have a gentleman in jail Zoom 6 with, well, glasses and brown hair. What's your, gentleman, glasses and brown hair. What's your name, please?
Oh, right here, Adams. I Yes, I barely can hear you now. I pushed the button.
Okay, what's your name?
Lewis Adams Jr.
Louis? Okay, hold on. So who's your attorney?
Mr. Maloro.
All
Judge,
right. Yeah,
Judge, hello, can you hear me? Hey, there we
yeah.
go. Judge, could we pass on that? He has numerous felony cases and I'm still assembling them so I can do a proper arraignment. Like, give
Okay,
me
well,
5
he's
minutes.
just, okay, he's gonna sit there. All right. I have another gentleman from the jail with glasses. Your ID is Spresser Zilke, but I can't tell what Zoom room you're in. You have gray hair. What's your name, please, sir?
Talking to me,
Yes, sir.
Mr. Schumate, Jerry Schumate.
All right. Okay, so let me, well, Mr. Bennett is your attorney, so hold on 1 second. All right, name right. There we go.
I'm in room 4.
Okay, thank you. Let me find your file. All right, Mr. Bennett.
Yes,
Where'd
Your
you
Honor.
go? Good morning. This is in the matter of the people of the state of Michigan versus Gary Edward Shoemate, file number 22-21076 FC. I have Jeffrey Bennett appearing on behalf of Mr. Shoemate, and I have Isaac Sneed, Jacqueline Weiss appearing on behalf of the people. So this is the date time set for a final pretrial conference. Mr. Bennett and Ms. Weiss, how do you wish to proceed today?
Your Honor, Ms. Wise and I spoke over text yesterday, and today's hearing was set to determine whether or not the second case was going to go forward to trial, and there was some question about whether or not that was going to happen if there was a conviction in the trial we did in February, which it was. My understanding is that the state intends to proceed to trial, so I think we just need trial dates.
All right, Ms. Weiss, is that correct?
That's correct. I think that 2 days would be sufficient if Mr. Bennett agrees.
All right, Ms. Adams, can I see the 25 book, or you can find the dates? No. Okay, I gotcha. Okay, so. You said 2 days, Ms. Weiss and Mr. Bennett?
Yes,
I
please.
would expect that 2 days would be sufficient. So, Mr. Bennett and Ms. Weiss, do you want this backed up to another case, or do you want a date that is solid?
I would like a solid date. Please.
I think that's appropriate based on the witnesses in this case. I think it'd be a little bit traumatic to
So-
have the,
I am stacked. The first open date I have for sure is March. Mr. Bennett or Ms. Weiss, March 25.
that date's available to me, Your Honor.
Ms. Weiss,
I'm not available the week of the 24th through the 28th of March, but pretty much any other time I am.
all right, I can do. I have an individual who's not in jail. I have 3 trials set the week of February 4th. None of them are in custody. I can bump those for this because it's an FC and he's in custody. February 4.
It's up to you, Judge. The fact that he's in custody, he's sentenced to MDOC at this time, so he's going to be. It's not going to that. Whatever you guys want to do.
So I can go to. I have a 10-day trial on Trenton Berry. Let's see. I can go to jury trial. I can go to April 8.
Mr. Shoemate, are you in the jail?
No,
Have
he's
you
at
been-
he's at the jail.
Yeah.
You don't, he doesn't show up in Otis, so you've been in jail since?
I've been in jail since last year.
Right, yeah.
Yeah, I think the plan is to send him to MDOC though, Mr. Bennett.
Right, I understand that, but if they have a trial, my concern is whether Mr. Shoemate wants to move on to MDOC, in which case I would rather have the February trial date. Or if it doesn't matter to him and he doesn't mind staying in Lenawee, then the April date would be fine. So are you fine if you stay in Lenawee until this trial, Gary?
I don't know that it's up to him. It's the jail, I think, has plans to send him to MDOC. So we can do the February date if you want.
Well, I can, let's see. I have, you know, what about January 21st?
I have a trial that week, Your Honor. We can do the April date. If he goes to MDOC, that's fine. It's just surprising that he's not there already.
Okay, but is MDOC gonna allow him civilian clothing for the trial?
Well, he'll be brought over to the Lenawee County Jail, I believe, for the trial, right? And so they have clothes there. I know that I left his trial clothes with the Lenawee County Jail that I had gotten for him.
Becky, can I see the 24 book? So, Ms. Adams, we have that motion on Blaker versus Massick. That's probably gonna get adjourned, right?
I believe so, Judge.
All right, I can do February 9 and December 9 and December 10. So I think that'll work.
Yeah, I guess if you want me to do those dates, that's okay. I do have a very large dinner party for my 40th wedding anniversary on December 8th. I'm not sure that, let's just say I've arranged for transportation, expecting to not be in a situation to drive on the 8th.
December 10 and December 11.
Okay.
All right, so we'll do December 10 and December 11. All right. 2 days. All right, I'm gonna do a final pretrial on, let's see, another final pretrial on November 27 at 8:30 in the morning. Oh, let's see, November 27. I'm going to require that that'll be the final motion deadline, November 27. And I'm going to order that jury instructions and voir dire questions be provided to the court by November 20. And I have filled out a scheduling order and we will get that out to everybody. Tuesday trials start at 9 a.m. Wednesday trials start at 10:30. Jury instructions are 1 instruction per page, all the information filled in. You guys can agree on them, that's great, but be prepared to discuss them at the final pretrial. Is there anything else we need to address, Mr. Bennett or Ms. Weiss?
No, thank you.
Honor.
All right, excellent. Thank you both, and thank you, Mr. Shoemate. We'll see you back on that day.
Thank you, Your Honor.
Thank you.
Judge, sorry to bother you. I think Williams is in your waiting room. Just letting you know. He's telling me he's in your waiting room.
I got Wesley Brook, jail, Samsung. It's probably a Samsung. We'll be with him in 1 second, Mr.
Take
Milan,
your time.
No, I'll just take care of Mr. Rogers first and then we'll go to him. All right,
Okay.
Mr. Malaro, you're ready on Mr. Rogers. So back on the record in the matter of the people of the state of Michigan versus Scott Allen Rogers. Mr. Malaro, where are you? Where's Mr. Malaro? Oh, there you are. Have you had an opportunity now to speak with Mr. Rogers?
I have, Judge, but I don't think I'm ready on Rogers yet, but I am ready on Mr. Adams.
Oh, that's the one you said you were ready on. I'm sorry. All right. So, Mr. Rogers, we're going to skip you again. So we're back on the record in the matter of the people of the state of Michigan versus Louis Alfred Adams Jr., file number 24-22011FH and 24-22012FH. I have Salvatore Malaro appearing on behalf of Mr. Adams. And I have Isaac Sneed appearing on behalf of the people. So, Mr. Sneed, how do you wish to proceed on behalf of Mr. Adams, or Mr. Malaro? How do you wish to proceed on behalf of Mr. Adams? This is a date and time set for arraignment on both of these files.
Yes, Judge, on the 011 FH file, we would acknowledge receipt of the information, waive its reading in open court, waive any defects of the time and place of service. Mr. Adams would stand mute to count the only count 1, and the habitual offender notice. We would further acknowledge receipt of the witness list. As to the 012 FH file, we would acknowledge receipt of the information on that, waive its reading in open court, waive any defects of the time and place of service. Mr. Adams would stand mute as to all 6 counts in that file, and any habitual offender notice. We'd also acknowledge receipt of the witness list. Judge, we would ask that these matters be set for pretrial. Mr. Adams has other matters in the circuit court that are scheduled for next week on the 30th. We'd ask that these be set for that time. And we're hopeful that there can be some form of a resolution.
All right, excellent. All right, I will enter a plea of not guilty on behalf of Mr. Adams on both of these files, and I will set them for pretrial on October 30th at 8:30 in the morning with his other files. And because it's arraignment, Ms. Adams will prepare the notice of hearing. Mr. Adams, thank you, and we'll see you next week, okay?
Judge, one other
Yes.
matter. It looks like there's a 949 FH file that's in Judge Olsaver's court. I don't know if the other ones are there but I think for judicial economy, if we can get them all in one court, I think that would be great.
Am I getting out on a break ankle monitor?
I do have one question, Judge. Was that pretrial set for October 30th?
Yes.
Okay.
And what about,
I have no objection to that question.
all right, can you do that by stipulation, or is it a lower number file or a higher number file?
Well, Judge, those other files are scheduled for the 30th. So we don't need to do a stip in order, and then I'll come over and speak to Mr. Adams on tomorrow.
So I'm not getting out on an ankle monitor?
Not today, Louis. I'm gonna come over and talk to you about it tomorrow, okay?
I thought that was the deal. If I waived that, you guys would get me on an ankle monitor.
Okay, that was not the
no,
deal.
that's up to me. So, all right, you're all set, Mr. Adams.
All right.
Thank you.
I'll come talk to you tomorrow, Louis.
Oh, man.
So let me get Mr. Williams in. I think this is Mr. Williams. All right, I have another gentleman at the jail with a beard. What's your name?
Bauer.
Yes. What is it?
Bauer.
All right. Jonathan Maurer, you're Mr. Malaros as well. So let me rename you because I'm getting. All right, Mr. Malaro. All right, I have somebody who's logged in on a Samsung device. Could you unmute and start your video, please? All right, that's Mr. Williams. Mr. Malaro, while I'm taking care of Mr. Mawad, do you need a breakout room with Mr. Maurer? I don't have audio. I'm so sorry. Yes.
Nah, it's okay. Yeah, Judge, just real quick. It shouldn't take too long with it.
Okay. I'm gonna stay in my repertoire of sign language for you. All right. Okay. All right, Mr. Williams. All right, this is in the matter of the people of the state of Michigan versus Nicholas Ryan Williams. We have two files. We have 23-21628FH and 23-21629FH. I have Elias Mawad appearing on behalf of Mr. Maurer or Mr. Williams, and I have Isaac Sneed appearing on behalf of the people. I have received a plea agreement form that is on file number 23-21628FH that states he will be pleading guilty to an added count 3 aggravated assault, which carries a maximum penalty of up to 1 year in jail, and an added count 4 stalking, which is also a 1-year misdemeanor, which carries up to 1 year in the Lenawee County Jail. There is a Killebrew sentencing agreement that he will be sentenced to 1 year in the Lenawee County Jail suspended upon any violation, 2 years probation, non-reporting, and that his tether will be removed on the day the plea is accepted. And it does not require sex offender registration. The people will dismiss count 1, CSE 3rd degree, and count 2, aggravated stalking. And then in file number 23-21629FH, they will dismiss the aggravated stalking charge, which is the only charge in that file. So file number 23-21629 will be nully crossed. Is that correct? Recitation of the plea, Mr. Sneed?
Yes, it is. Thank you, Your Honor.
And Mr. Mawad, is that the plea offer as you understand it?
Yes, but Judge, he's going to plead no contest. It was guilty or no contest. We just think it's better if it's a no contest plea. I know the court knows the history of potential civil liability and all that stuff. And I would stipulate to any police reports or anything you want me to stipulate to, that's fine.
All right. So, Mr. Sneed, are you able to put factual basis on the record?
Yeah, I'll just need a moment to bring up the police report or the information, Your Honor.
Sorry.
That's fine. While I arrange, is it enough time while I arraign him, or do you want me to move to the next case for a minute?
Your Honor, if you wouldn't mind moving to the next case.
Okay. So, Mr. Malaro, let's back to Mr. Maurer. Oh, gosh. So, in the matter of the people of the state of Michigan versus Jonathan Remington Maurer, we have 4 files, 24-22004FH, 24-22005FH, 24-22006FH, and 24-22007FH. I have Salvatore Malaro appearing on behalf of Mr. Maurer. Oh, looks like this is actually the date and time set for arraignment on all these files. So and I have Isaac Sneed on behalf of the people. So Mr. Malaro, how do you wish to proceed today? Do you waive the reading of the felony information? I can't hear you. No.
How about now?
Now I can.
All right. Okay, Judge, as to 004FH, we would acknowledge receipt of the information, waive its reading in open court, waive any defects of time and place of service. Mr. Maurer will stand mute as to counts 1 and 2 in the habitual offender 4th notice. We further would acknowledge receipt of the witness list. We'd ask that the court enter a not guilty plea on that file and set it for pretrial. As to 005FH, Mr. Maurer would acknowledge receipt of the information in that matter. Waive its reading in open court, waive any defects of time and place of service. Mr. Maurer would stand mute to counts 1 through 5 in the 4th habitual offender notice. We'd further acknowledge receipt of the witness list and ask that the court enter a not guilty plea on his behalf and set that for pretrial. As to 006FH, Mr. Maurer acknowledges receipt of the information in that matter. Waive its reading in open court, waive any defects of time and place of service. Mr. Maurer would stand mute as count 1 in the habitual offender 4th notice. Now, just further acknowledge receipt of the witness list. We'd ask the court to enter not guilty plea and set the matter for pretrial. As to the 007FH file, Mr. Maurer would waive its reading in open court, waive any defects of time and place of service. We further would stand mute as to counts 1 through 3 and the habitual offender notice. We'd further acknowledge receive the witness list. We'd ask court to enter not guilty plea on that matter and set all these matters at the same time for a pretrial, for which we're hopeful we can have a resolution in place. And if we can get one done sooner, we will contact the court to put a plea on. Thank you, Judge.
How far would you like a pretrial, Mr. Malaro?
Judge, we need less than 30 days, I think.
All right. I can do November 13th or November 3rd or October 30th.
Okay, we can do the 30th.
Okay. All right, so Mr. Maurer, I will enter a plea of not guilty on your behalf on all of these files. And then we will have this set over to October 30th for a pretrial. And my staff will prepare the notice of hearing because it's an arraignment. All right, so Mr. Maurer, you are all set. Thank you very much.
Yeah, what day was that?
Next Wednesday, October 30th, the day before Halloween.
Okay, thank you.
All right, thank you. All right, I'm gonna open up a breakout room. Mr. Malaro, you said you need to speak with Mr. Rogers, correct?
Yes, Judge.
All right, go ahead and join that breakout room. All right, Mr. Sneed, do you need more time, or are we good to go back to Mr. Williams?
I'm ready, Judge. Thank you.
All right. Okay, so that's Rogers. All right, so we are back on the record in the matter of the people of the state of Michigan versus Nicholas Williams. Mr. Sneed is now prepared for the no contest plea. So Mr. Williams, I'm going to swear you in. Can you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, can you state your full name for the record?
Nicholas Ryan Williams.
All right, so Mr. Williams, you've heard the statement. Well, I read off the plea agreement form and then discussed it with the prosecutor and your attorney. Is it your intention today to plead guilty or no contest on file number 23-21628FH to count 3 aggravated assault and count 4 stalking, both of which carry a maximum penalty of up to 1 year in jail? So is it your intention to plead no contest to those today?
No contest is correct, Your Honor.
Okay, and you understand there was a sentencing Killebrew agreement between your attorney and the prosecutor that would be given a 1 year jail term, but it would be suspended upon any violation along with 2 years probation. So you understood the sentencing agreement as well?
2 years probation, correct, Your Honor.
Okay, are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Mawad?
That is correct, Judge.
And Mr. Sneed?
Yes, Your Honor.
All right. And as far as you're aware, Mr. Williams?
Nick, that's the agreement we've reached, right? You're not aware of any other
I'm
statements?
sorry, the judge broke up about 3 seconds ago. I heard her talking to me and then she broke up.
Yeah, it's okay. And he's got a little bit of a delay. So as far as you know, no one discussed any other sentencing agreement with me. Is that correct, Mr. Williams?
Not that I know of, Your Honor.
Okay, so Mr. Williams, if a guilty plea is accepted, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, sir, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that, Mr. Williams?
I believe so, Your Honor.
Well, is that a yes or a no?
Yes.
Okay.
Sorry.
So you understand that had you been convicted at trial, you would have had more automatic rights to appeal, but by entering a plea, you don't have an automatic right.
Yes.
Right? Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? You understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All
No, Your Honor.
right, and your actions on this would be to plead no contest or not guilty. So, Mr. Williams, on file number 23-21628, how do you plead to the charge that on or about June 1 of 2022 in Adrian Township in the county of Lenawee that you did commit?
Yes.
And then on June 1 of 2022 in Adrian Township in the county of Lenawee, how do you plead to the charge that under count 4 that you did commit the offense of stalking? No contest or not guilty?
No contest.
All right. And that was in Adrian Township, correct?
Yes.
Okay. All right. Has anyone made any threats or promises to you to induce you to plead no contest to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain and the Killebrew agreement to induce the defendant to plead no contest?
No, Your Honor.
No, Your
All right,
Honor.
Okay, so Mr. Williams, other than the agreement that was put on place on the record, has your attorney promised you any other particular sentence in terms of fines, costs, or anything like that?
No.
Okay. All right, so it's your own choice to plead no contest?
Yes.
All right, so Mr. Sneed, would you like to place the factual basis for count 3 aggravated assault and count 4 stalking on the record, please?
Your Honor, yes, on or about June 1st of 2022 in the township of Adrian, county of Lenawee, and state of Michigan, the defendant, Nicholas Williams, did engage in a vaginal penetration of Cameron Williams, his former wife, using force or coercion to accomplish the sexual penetration. Next, in regard to the stalking, it's true that Nicholas Williams did engage in a willful course of conduct involving continuous harassment of Cameron Williams. The conduct which would cause a reasonable person to feel harassed and intimidated, and said conduct actually did cause Cameron Williams to feel harassed or intimidated, and at least one of the actions did constitute a violation of a PPO dated February 7th, 2023. Those actions included violations of the PPO on May 20th of 2023, reference Adrian City Police Report 230005151, appearing at his daughter's soccer game where Miss Williams was in attendance. And second, on May 27th, 2023, Adrian City Report 230005435, appearing again at daughter's soccer game in violation of the personal protection order. I think with that, Your Honor, we've satisfied the elements of both charges. Thank you.
Mr. Mawad, any additions or objections?
No, Judge, because this is a no contest plea, the reading of the reports are right way to do it, and so there's no objection.
All right, well, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on June 1 of 2022 in Adrian Township in the county of Lenawee, that the defendant did commit the offense of, let me go back there, of aggravated assault by using force or coercion to vaginally penetrate the victim in this matter. And then as to count 2, that on June 1 of 2022 in Adrian Township in the county of Lenawee, that the defendant did commit the offense of aggravated, well, let's go back to stalking in violation of a PPO that was in place by showing up at a soccer game and other places and behaving in a way that caused the victim in this matter to be threatened or intimidated, and again is a violation of the personal protection order that was put in place. Therefore, the court does find that the defendant committed the offense of aggravated assault and stalking and accepts the no contest plea. Mr. Mawad, has court complied with MCR 6.302 B, C, and D?
Yes, Judge.
Mr. Sneed?
Yes, thank you, Your Honor.
All right, the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel, and I accept the plea. This court has made no agreement regarding the possibility of a plea or possible sentence in this case, other than what the prosecutor and the defense attorney and the defendant placed on the record in terms of a Killebrew plea. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. Mr. Mawad, are you available on December 20th at 8:15?
Yes, Judge. That would be fine. No problem.
All right, I'm going to set this for sentencing on December 20th at 8:15 in the morning. Mr. Williams, next Thursday morning, not tomorrow, but the following Thursday morning, which is Halloween, I need you to report to the district court probation department between 8 and 10 and check in there. That's the probation department on the first floor because these are misdemeanors. Mr. McCarron will meet with you, and when you meet with them, obviously you don't need to make a statement regarding the events that occurred for these charges because you did plead no contest, but be truthful with him about your background, and he will prepare a pre-sentence report. We will provide that to Mr. Mawad. Mr. Mawad will review that with you before sentencing, and we will see you back on December 20th at 8:15. Now, Mr. Williams, there is no recommendation of a jail term. Do you wish to appear via Zoom or do you wish to appear in person?
Zoom's fine, Your Honor. Did you say on Halloween on Thursday?
Next Thursday, you need to report to district court probation between 8 and 10 a.m.
Is there any chance I can do it on Friday? I have my kids and I don't have a babysitter.
You're going to be in school, aren't they?
Not the little ones. The 3 and 5-year-old will not be.
That's only, well, you could go the following Thursday, I guess.
That would be
So
greatly
you can
appreciated, Your Honor.
I'm sorry.
I said that would be greatly appreciated.
All right, November 7 between 8 and 10 a.m. All right, so we are all set. Thank you, Mr. Mawad and Mr. Sneed. We'll see you back on December 20th at 8:15 in the morning via Zoom.
All right. Thank you. Thank you, Nick. Thank you, Isaac. Thank you. Bye-bye.
All right, Mr. Malaro. We are back with you. And I have, took care of that one. I have Mr. Rogers back. So let me find him on my docket. All right, so Mr. Malaro, have you had a chance to speak with Mr. Rogers? No, nothing. I got nothing.
How about now?
I can hear you now. I am so sorry, Mr. Malaro. All right.
I'm not doing it on purpose, I swear. As an
I
officer of the
know.
court.
So how would you like to proceed on behalf of Mr. Rogers today?
Your Honor, I believe we have reached an agreement to resolve both cases. The agreement is as follows. On the 764FH file, Mr. Rogers will plead guilty as charged to counts 1 and 2 with a habitual offender third supplement. As to the 815FH file, Mr. Rogers will plead guilty as charged to counts 1 and 2 the habitual offender third supplement. There's a sentence agreement of 48 to 120 months in the Department of Corrections. Both
hold on, you're going faster. What's the agreement for sentencing?
48 to 120 months in the Michigan Department of Corrections. Both files will run concurrent.
Right, so 48 to 120 on each file?
Correct.
Okay. I just, hold on one second. Because, with the third, okay, I got it.
Well, in the event, Judge, one of them does not have a 48-month sentence, it would be concurrent either way.
Okay. All right,
And
I'm
these-
not worried, Mr. Rogers, about it being more. I just wondered if the guidelines would come in less, so it's not a problem. Anything else, Mr. Malaro?
In the 764 FH file, the habitual fourth supplement will be dismissed. In the 815 FH file, counts 3 and 4 and habitual fourth will be dismissed. Restitution shall be determined by the court. Mr. Rogers in paragraph 9 acknowledges that entering a plea requires a mandatory minimum sentence. Further, he acknowledges by entering this plea, it includes a habitual offender supplement, and the plea must be accepted by today. And by doing this, it resolves all matters, and the trial set for November 5th would be vacated. That is our plea agreement, Your Honor.
Okay, so let me get this straight, because I don't have the plea agreement form. On file number 24-21764FH, he's gonna plead guilty to count 1, possession of meth, count 2, possession of cocaine. Those are a 10 and a 4-year felony respectively, but he's gonna plead with a habitual offender third offense notice, correct?
Yes, that is correct.
So the 10, 15, 20, the 10-year becomes a 30-year? Or 20? Because it'd
Did we
be
say 120? It should be 240, I think. Should be 240.
240. With a third offense notice, a 10-year becomes it wouldn't be 15, 20. What would be the
20.
maximum penalty?
20.
And this is why lawyers went to law school and didn't become math teachers.
It's 20.
So it becomes a 20 with the third offense? Okay.
I believe so.
Mr. Steve?
Yeah, I agree, Your Honor. Thank you.
Okay. And then the 4-year becomes an 8. Right?
Correct.
And then, okay. And then larceny 1,000 or more, but less than 20. This is only pleading to count 1 and 2 on file number 815, count 3, 4 would be dismissed. So it would be a 10-year on the larceny, 1,000 or more, but less than 20. And then on the count 2 R&O, that's a 2 years, so it becomes a 4-year, correct?
Correct.
Okay, okay. All right, and Mr. Rogers, you want to raise your right hand for me? Sorry about all that. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record?
Scott Allen Rogers.
Okay, so Mr. Rogers, you've heard the statement of your attorney and the prosecuting attorney on file number 24-21764FH. Is it your intention to plead guilty to count 1, controlled substance, possession of methamphetamine, which with a third offense notice carries a maximum penalty of up to 20 years in prison?
Yes, ma'am.
And on count 2, and to plead guilty to count 2, controlled substance, possession of cocaine, less than 25 grams, which carries with a third offense notice up to 8 years in prison. So is it your intention to plead guilty to both those counts?
Yes.
Okay, and then you understand there was Killebrew agreement that you would serve 48 to 120 months on those.
Yes.
Well, and 240 on the other one. Okay. So a maximum of 240 on the one. So okay, so then on file number 24-21815FH, is it your intention to plead guilty to count 1, larceny 1,000 or more, but less than 20,000, which will carry with the third offense sub a maximum penalty of up to 10 years in prison? And then count 2, police officer assaulting, resisting, and obstructing with the third offense sub will be up to 4 years in prison. And again, the guidelines and the sentence range by Killebrew agreement would be 48 to 120 months. So is it your intention to plead guilty to both those counts?
Yes, ma'am.
Okay, and are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, ma'am.
All right, and neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro? Hold on a second.
That's correct, Judge. That is correct.
Yep. Hold on one second.
Standing up, sir, my legs. What's your last name?
Raleigh. Joshua Raleigh.
Sorry. What's your name?
Joshua Raleigh.
Okay, hold on. We'll take you next. Okay. Who's your attorney? All right, I have him. So hold on. All right. So, all right. So, Mr. Rogers, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. And you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Rogers, do you have any questions about the rights that I've given to you?
I do not.
All right, so let's start with file number 6-4. Mr. Rogers, how do you plead to the charge that on December 27th of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance, possession of methamphetamine or ecstasy, guilty or not guilty?
Guilty.
And how do you plead to the charge that on the same date, time, and jurisdiction, under count 2, that you did commit the offense of controlled substance, possession of cocaine less than 25 grams, guilty or not guilty?
Guilty.
All right, and then let's move on to file number 24-21815FH. Mr. Rogers, how do you plead to the charge that on or about April 19th of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense under count 1, larceny 1,000 or more, but less than $20,000, guilty or not guilty?
Guilty.
And count 2, police officer assaulting, resisting, and obstructing, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than the plea agreement placed on the record?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of threats or inducements other than the plea bargain to induce you to plead guilty?
Yes.
Mr. Malaro? No.
No other, nothing further has been submitted other than what I read into the record.
All right, it was very faint, but he said no other and nothing other than what was placed in the plea agreement form.
Yes, that's what I said.
Okay, Mr. Sneed?
No, Your Honor. Thank you.
Do you understand that if I, let me see here, has your attorney promised you any other particular sentence, Mr. Rogers?
No.
And it's your own choice to plead guilty?
Yes.
All right, so Mr. Rogers, on file number 24-21764FH, on December 27th of 2023, we're in the city of Adrian in the county of Lenawee.
Yes.
And at that time, did you have in your possession methamphetamine?
Yes.
Did you know it was methamphetamine?
Yes.
Where was it?
In my pocket.
All right, and you had no legal right to possess that, is that correct?
Correct.
All right, and Mr. Rogers, did you also have in your possession less than 25 grams of cocaine?
Yes.
And you knew that was cocaine?
Yes.
And you had no legal right to possess it?
No, ma'am.
All right, so Mr. Rogers, back on, let's see, June 9th of 2021, you were convicted of retail fraud first degree in the 39th Circuit Court of Lenawee County, is that correct?
Yes.
All right, and then on August 31st of 2022, you were convicted of the controlled substance possession of analogs, is that correct?
Yes.
Okay, and you also have a larceny from a motor vehicle back on August 31 of 22, is that correct here?
Yes, ma'am.
Okay. Move on to file number 24-21815FH. So Mr. Rogers, on April 19th of 2024, we went in, so it doesn't give me jurisdiction, but it's Tractor Supply. So is that Adrian, right?
Madison.
Madison?
Yes, ma'am.
Okay, were you in Madison Township in the county of Lenawee?
Yes.
Right, and you were at Tractor Supply over on 223, right?
Yes.
All right, and under count one, larceny, 1,000 or more than less than $20,000. Did you steal a Toro lawnmower and a Dr. Wood Chip Shred Premier 300?
Yes.
And that belonged to Tractor Supply Company, the business, correct?
Yes.
And when you stole that, your intention was to deprive them of the value of that?
Yes, ma'am.
And you had no right to take that, correct?
No, ma'am.
All right, and would you agree the value was more than 1,000 but less than 20?
Yes.
Okay, now at some point you came in contact with a Lenawee County Sheriff named Forrest Howard, is that correct?
Yes.
And was it daytime or nighttime?
Nighttime.
All right, did he turn the lights on his vehicle and try to stop you?
He never turned the lights on, no.
Okay, so how'd you know he was a sheriff's deputy?
By his car, the paintings.
So where did you come across him? Was it at Tractor Supply or?
I was pulling out. He was pulling in.
Okay, so did he try to take you into custody?
Yes, ma'am.
And he had a uniform on?
Yes.
And he was driving a sheriff's vehicle?
Yes.
Okay, so tell me what you did. Did you run? Did you try to drive away? You ran? Okay. All right, and you would agree that would constitute assaulting or resisting a police officer, correct?
Yes, ma'am.
Okay, now you also have, I'm gonna go through your prior felonies again. So on August 31 of 22, you were convicted of attempted larceny from a motor vehicle in the circuit court here, correct?
Yes.
And then on June 13 of 23, you were convicted of larceny in a building in the circuit court of Lenawee, correct?
Yes.
And then you have that retail fraud first degree back on June 9th of 2021, is that correct?
Yes, ma'am.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Malaro?
How about a thumbs up?
Yes, you have complied with the court rule.
All right, thank you, Mr. Malaro. Mr. Sneed?
Yes, thank you, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement myself regarding the possibility of a plea or possible sentence in this case, but there is a Killebrew agreement between the prosecutor's office and defense counsel, and the court will of course honor that. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available on December 20th at 8:15 in the morning?
I am, Your Honor. Yes, I am.
All right. Mr. Sneed, just for my notes, the items were recovered, right? So there's no restitution?
Your Honor, I think they were recovered. I just don't know whether they were damaged or not during the theft.
Okay.
And
There may be damage to, I think, a police car.
Okay. All right. So, Mr. Rogers, somebody from the probation department is going to come over and meet with you. Be truthful with their background, about your background and the events that occurred. They'll prepare a pre-sentence report. We will get a copy of that to Mr. Malaro. He'll meet with you in advance of sentencing. We'll see you back on December 20th at 8:15. So, Mr. Rogers, do you want to appear in person or via Zoom?
Zoom will be fine.
Okay, so that'll be Zoom, and we're all set. Thank you, Mr. Rogers.
Thank you. Thank you, Mr. Malaro.
All right.
Thank you, Mr. Rogers.
Prophet, thank you. Mr. Murphy should be finishing up, and Judge Olson, oh, I got him. And then I've got Mr. Dagger Margosian. I have Mr. Rowley in the courtroom. He's been here since 8 o'clock. I don't know, that was kind of biblical, Mr. Dagger Margosian. You had like the halo.
Yeah, I got to put a halo over my head then, just.
All right, Mr. Rowley, why don't you come up to the podium? Mr. Murphy, do you need a breakout room with Mr. Prophet?
Yes, please.
All right, so Mr. Prophet, I'm going to put you in a breakout room with Mr. Murphy to give you a minute to talk. So let me find you. There you are. All right, go ahead and join that breakout room. All right, this is in the matter of the people of the state of Michigan versus Joshua Dexter Rowley, file number. We have two files, 24-21911FH and 24-21957FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Rowley. This is the date and time set for pretrial on file number 24-21911FH and arraignment on file number. Why does it say arraignment? I don't think it is. Let me see here. Oh, yeah, arraignment on file number 24-21957FH. So on 24-21957FH, Mr. Dagger Margosian, do you waive the reading of the felony information?
Yes, Your Honor.
And okay, so Mr. Dagger Margosian, how would you like to proceed today?
Well, Your Honor, on both of the files, I believe that we have a resolution. The proposed offer is that Mr. Rowley would plead guilty to one count of DV second on each of the files, and in exchange, the original information would be dismissed. Additionally, there is an agreement for a 1-year suspended jail sentence, no upfront jail, and no contact with Tim Williams. And my understanding is that we'll be entering that today.
Is that a correct recitation of the plea, Mr. Sneed?
yes, it is.
All right. Okay, Mr. Rowley, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, you're going to need to speak up a little bit. You are soft-spoken. So, Mr. Rowley, you've heard the statement of your attorney and the prosecuting attorney. On each of these files, you are charged with a third offense, domestic violence. Let me double check. And the plea offer in this case, and there's no habitual offender third offense notice either, right?
Correct.
So
Right. It would be misdemeanor.
We'll be adding a count to domestic violence second offense on both files, correct, Mr. Sneed?
That's correct, Your Honor. Thank you. We just found out this morning there's going to be a plea.
Oh, no, it's not a problem. I'm happy to accommodate in any way I can. All right, so, okay. So, Mr. Rowley, you understand that the plea offer is on each file to plead to an amended information added count to domestic violence second offense.
That's right.
That carries a maximum penalty of up to 1 year in jail. There'll be a 1-year jail term, but it'll be suspended And if you violate, you'll serve that term. Do you understand that?
Yes, ma'am.
All right, are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
All right. Neither, other than that agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Mr. Sneed?
Yes, that's correct, Your Honor.
Mr. Dagger Margosian?
Correct, Your Honor.
And as far as you're aware, Mr. Raleigh?
Yes.
Okay. All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. All right. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, so let's start with file number 24-21911FH. So, Mr. Raleigh, how do you plead to the charge that on or about March 9th of 2024 in Raisin Township in the county of Lenawee that you did commit the offense of domestic violence second offense? Guilty or not guilty? All right, and then on
I'm sorry.
so then on file number 24-21957FH, how do you plead to the added count 2 that on or about June 11th of 24 in Clinton Township in the county of Lenawee? Clinton Township? Do we have a Clinton Township in Lenawee?
Village of Clinton. Village of Clinton.
Should be
We don't have-
village, Your Honor.
All
But we'll be
right.
submitting
Let's
amended
say-
informations on both of the files, so.
Okay, in the village of Clinton in the county of Lenawee that you did commit the offense of domestic violence second, guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to induce you to plead guilty to these offenses other than what was placed on the record?
No, ma'am.
Is anyone, let me see, do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, I understand.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor, thank you.
Mr. Dagger Margosian?
None, Your Honor.
Okay. Has your attorney promised you any other particular sentence or estimated what your sentence would be in terms of probation, fines, costs?
No, ma'am.
Okay. Is it your own choice to plead guilty?
Yes, ma'am.
All right. So, Mr. Raleigh, on file number 24-21911FH, were you on March 9th of 24 in Raisin Township in the county of Lenawee?
Yes, ma'am.
And were you in the presence of an individual named with the initials of KW?
Yes, ma'am.
All right. And did you assault her?
Yes, ma'am.
All right. Did you punch her, push her, pull her, pinch her, slap her?
Pushed her.
You pushed her, and you were dating her?
Yes, ma'am.
And she didn't give you permission to push her?
No, ma'am.
All right. Are you satisfied on that file, Mr. Sneed?
Yes, Your Honor, thank you.
Okay. So let's move on to 24-21957FH. So Mr. Raleigh, on June 11th of 2024, were you in the village of Clinton in the county of Lenawee?
Yes, ma'am.
And at that time, were you with, again, the individual with the initials KW?
Yes, ma'am.
And did you assault her?
Yes, ma'am.
What'd you do?
Slapped her.
You slapped her? And you were dating her at the time?
Yes, ma'am.
Okay. Okay, are you living in Kalamazoo now, or are you back here?
No, I'm in Kalamazoo.
Moved to Kalamazoo, okay. All right, are you satisfied with the plea on that one, Mr. Sneen?
Yes, thank you.
Mr. Dagger Margosian, has court complied with MCR 6.302 B, C, and D? Mr. Dagger Margosian?
Yes, Your Honor, thank you.
Mr. Sneen?
Yes, Your Honor, thank you.
Okay, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Killebrew agreement that was placed on the record, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of any of them. So, Ms. Adams, I'm going to need a notice of hearing for sentencing on December 20th. I'm going to refer this matter, oh, never mind, these are misdemeanor pleas, but I will need a notice of hearing for sentencing. So you drove here today, right?
I had a ride, yes, ma'am.
Okay, so I'm gonna, because you had to drive, do you want to appear for sentencing in person or via Zoom?
If possible, Zoom.
Okay, because there's an agreement to no upfront jail, I'm gonna set sentencing for December 20th at 8:15 in the morning. Ms. Adams, could I get a notice of hearing for him along with a Zoom notice?
Okay.
Okay, so because you pled to a misdemeanor, the district court probation department will prepare the pre-sentence report. When you meet with them, be truthful with them about your background, the events that occurred. I'm gonna send you down there today.
Okay.
I don't know that they'll be able to see you. And then Ms. Adams, could we expedite a judgment of sentence down to Mr. McCarron?
Sure.
She's like, sure. So I'm gonna have you go downstairs and ask, you know who Mike McCarron is?
No, ma'am.
No, go downstairs, ask if you can talk to Mr. McCarron. Tell him I sent you, that you live pretty far away and don't have a car, and see if he'll talk to you today. Otherwise, you're just gonna give them their information and they might give you a packet, okay?
Okay.
And I'll get you a notice of hearing for sentencing. You can appear via Zoom for that. Anything else, Mr. Sneed or Mr. Margosian, Dagger Margosian?
No, thank you, Your Honor.
No, Your Honor, thank you.
Mr. Dagger, make sure you keep your information updated with Mr. Dagger Margosian, because when he gets a report, he will contact you and review it with you before sentencing, all right?
Okay.
So I have a seat right behind you. We'll get you the Zoom notice along with a notice of hearing for sentencing, and then go down to district court probation.
Okay.
All right, just right there.
Oh.
Right there, yeah. Okay, so, we got Mr. Prophet. Hold on, I got North and Main, Brookby, I don't know what that is. I got waived. Did this. Rhonda Underwood, do you need a breakout room with Brooke Bates?
I don't believe so, Your Honor.
Okay, Mr. Malaro, where you at? I do not have William Byram. Is he at your office?
Your Honor, I am reasonably assured he is not at my office.
Okay, so I'm gonna call this one real quick. In the matter of the people of the state of Michigan versus William Sean Byram, file number 24-21959 FH, 24-21960 FH, 24-21961 FH, 24-21962 FH, 24-21963 FH. I have Salvatore Malaro on behalf of Mr. Byram, and I have Isaac Sneed on behalf of the people. I have a letter dated October 22nd from Darren Coast stated a violation was initiated. Mr. Byram had missed 2 drug screens in a row. He then mixed his next 5. Now we're at 7. So I'm going to issue a bench warrant for his arrest here. Okay, and I'm going to set bond in the amount of $50,000 cash on, I think it's too many, on each of the files. All right, we obviously will hold that bench warrant for 48 hours in the event that you locate them. So, and up here, 50K cash. All right. All right, so then Mr. Malaro, hold on. I think, Mr. Malaro, that's all I had with you, right?
I hope so. Thank you, Your Honor.
Thank you. And hold on 1 second. I have Noah well, I'm just gonna text you. I have Noah Finley, I have Brooke B. So let's go back to Mr. Prophet real quick. So in the matter of the people of the state of Michigan versus Archie Noah Prophet, file number 24-21950FH. I have, okay, so this is a motion, is that correct? Is that today?
No.
No, okay.
Mr. Prophet should just be
So
a
this
pretrial
is-
today.
Okay, so this is the date and time set for pretrial on behalf of Mr. Prophet. I have Isaac Sneed on behalf of people and Matt Murphy appearing on behalf of Mr. Prophet. I do show a plea offer was made at one time. If he were to plead guilty to count 1, controlled substance possession of methamphetamine, there would be no subs. The other charges would be dismissed. And any sentence he would have would run concurrent to his parole violation. He has a 4th offense notice, so if he were convicted at trial of count 1 and count 2, he would be facing life in prison. So, Mr. Murphy, how do you want to proceed today on behalf of Mr. Prophet?
Your Honor, Mr. Prophet wanted to accept the offer today. I guess I just wanted to clarify, was there anything else that was, okay. So he did want to accept the offer to plead guilty to count 1, possession of methamphetamine with no habitual, no subs, dismissal of the remainder, and concurrent sentencing possible.
Okay, Miss Adams, I have a note in the file that we don't have fingerprints, but he's kind of a captive audience, so I don't know how we don't have fingerprints. But anyway, we'll check on that on this file. So, Mr. Sneed, is that a correct recitation of the plea?
Yes, it is, Your Honor. Thank you.
All right, so Mr. Prophet, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you are Archie Noah Prophet.
Yes, Your Honor.
All right, so Mr. Prophet, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to, let's see, it's count 1, I lost my page. So it's count 1, right, Mr. Murphy? Yep.
Yes, Your Honor.
Is it your
Possession of
intention
methamphetamine.
today to plead guilty to count 1, controlled substance possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $15,000 fine with the rest being dismissed? Is that your intention, Mr. Prophet?
Yes, Your Honor.
All right, are you satisfied with Mr. Murphy as your attorney
Yes, Your Honor.
and the advice that he's given you as well?
Yes.
All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Murphy?
Yes, Your Honor.
And Mr. Prophet, as far as you're aware, is that correct?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Prophet?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Prophet?
No, Your Honor.
All right, how do you wish to plead to the charge that on or about August 10 of 2024 in Adrian Township in the county of Lenawee, that you did commit the offense of controlled substance possession of methamphetamine, guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
All right, do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, we have a plea agreement though. Is that correct?
Yep. Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, thank you.
Mr. Murphy?
No, Your Honor.
I might have repeated that, I don't know. So, Mr. Prophet, other than the plea agreement that it would run concurrent with your parole violation, you've not been promised any other particular sentence or given any other estimates, right?
Correct, Your Honor.
Right. Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, Mr. Prophet, on August 10th of 2024, were we in Adrian Township in the county of Lenawee?
Yes, Your Honor.
And did you have in your possession methamphetamine?
Yes, Your Honor.
Did you know it was methamphetamine?
Yes.
Did you have any legal right to possess it?
No, Your Honor.
And where did you have it at?
In my pocket.
Are you satisfied with the plea, Mr. Sneed?
I am, thank you, Judge.
Okay, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed
Yes, Your Honor.
and Mr. Murphy?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to set this matter for sentencing on December 20th at 8:15 in the morning. Mr. Prophet, someone from the probation department will come over and meet with you. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Murphy. Mr. Murphy will review that with you before sentencing, and we'll see you back on that date. Mr. Prophet, do you wish to appear in person or via Zoom?
Zoom is fine.
Okay. All right.
Judge,
Thank you, Mr.
Wait, I have a question about this concurrent to parole. We can't do that.
Well, I can craft something. So
Your Honor,
I just don't want that to be part of the plea because we can't do that.
I can craft a sentence that would allow for that based on what I decide to do. So they understand. So Mr. Prophet, you understand MDOC doesn't allow a concurrent sentence on parole, but the prosecutor and your attorney have made that agreement. So I would have to craft a sentence that would in some way comply with that. Do you understand?
Yes.
Okay. All right. We'll see you back on that day.
I'm
Thank
sorry,
you.
Your Honor. I just wanted to make sure he's still on a parole detainer, correct?
I don't know.
Because I wasn't sure if that was, because I thought he was the last information I had. And if he wasn't, I didn't know if we were willing to address bond today or not. But I'd assumed that he was still on the parole detainer and that would be keeping him in. So
I wouldn't have that information.
well, let me look into that, and if I'll talk to you, Mr. Prophet, and if we need to, I'll file a motion. But obviously, if you're being held on the parole detainer, I guess that's going to cause an issue with trying to get that. But let me just talk to you later about that. Okay.
All right.
Thank you.
The December 20th is as soon as we can get sentencing.
Yes, sir. It'll take that long to prepare the pre-sentence report. So thank you.
Thank you.
Thank you, Your Honor.
All right. Okay. Miss Underwood, I have Brooke Bates, And Mr. Fry, I have Noah Finley. Are you anticipating a plea, Mr. Fry?
No, Your Honor.
All right, Ms. Underwood, are you anticipating a plea?
I'm sorry, Your Honor. Ms.
You
Bates has another case that has
No,
finally.
hold on. My question was, are you anticipating a plea today, yes or no?
No.
Okay. All right, let's get them logged on. Ms. Bates, can you start your video, please? You can come up, Ryan. Okay, good. Can you hear me, Ms. Bates?
Yes, I can.
Okay, this is in the matter of the people of the state of Michigan versus Brooke Bates. We have two files, 24-21990, FH, 24-21926, FH. I have Rhonda Underwood appearing on behalf of Ms. Bates. I have Isaac Sneed appearing on behalf of the people. This is the date and time set for pretrial. Ms. Underwood, you may proceed then.
Thank you, Your Honor. Your Honor, Ms. Bates' third case has finally made it to district court. We are scheduled for a probable cause on the 28th. So I would ask, I guess, for a pretrial date a couple weeks after that.
My next available pretrial date is November 13. Would that work?
That works.
And then if you do a waiver, I mean, either if she gets bound over or whatever, if you do a waiver, put a note on there to set it over to November 13 for pretrial.
My thoughts exactly, Your Honor.
All right. So Ms. Bates, I'm going to adjourn this pretrial to November 13th at 8:30 in the morning. Ms. Underwood, you'll prepare the stip in order to adjourn. Mr. Sneed, can you sign your name with permission?
Thank you.
Yes, thank you.
Okay. All right. Thank you. Ms. Bates, you are all set.
Okay, thanks. Have a good day.
You too. And Ms. Underwood, I don't think I had anything else with you, correct?
Did Mr. Tyndall appear, Your Honor?
He did, but he didn't ask for court. Yes, he did. And he asked for court-appointed attorney. He just recently had surgery, so I set it over to next Wednesday.
And did you appoint us on it, Your Honor?
Yes.
Okay. And
yes.
what about the Washington extradition?
That was canceled because the prosecutor objected to it at this time because he has pending charges.
Okay. So Mr. Tyndall is next Wednesday, Your Honor?
October 30th at 8 o'clock. And yeah.
Thank you very much, Your Honor.
Court-appointed counsel. Thank you. Who is Kelly Mahoney? You're both of you. Okay. All right. So do you know where they are?
Kelly Mahoney. She is in the Jackson County Jail.
Okay.
Arrangements were made or not. Last year they were supposed to be, but.
All right, Mr. Finley, you want to start your video? And there you go. Thank you. This is in the matter of the people of the state of Michigan versus Noah Michael Finley, file number 24-21954FH. I have Brian Fry appearing on behalf of Mr. Finley. This is date time set for a first pretrial in this matter. Mr. Fry represents Mr. Finley, and I have Isaac Sneed on behalf of the people. So is there a plea offer in this file?
I think there was a plea offer where if my client pled as charged, the prosecuting office would have no objection to HIDA.
Okay. All right. Plead as charged to all three counts.
Maybe Mr. Sneed can, so Mr. Bayonetto is the prosecutor on this, Your Honor, and he's obviously out right now. So we're going to be asking for an adjournment.
Okay.
My understanding he's supposed to come back in November sometime, and we can have some discussions at that point.
Okay, so I'm going to set this for is November 27, okay?
That should be fine, Your Honor.
All right, I'm going to set this for pretrial, Mr. Finley, on November 27 at 8:30 in the morning. So you'll do the step in order to adjourn, Mr. Fry?
Yes, I can do that, Your Honor.
All right, so Mr. Finley, we'll see, can you hear me? Okay,
Yes, Your Honor.
okay, so we'll see you back on November 27 at 8:30 in the morning, okay?
Thank you. I understand.
All right, thank you, Mr. Finley.
Mr. Sneed, could I sign your name with your permission to that step in order?
Thank you.
Thank you.
Okay, so let's move on to the matter of the people of the state. You're all set, Mr. Finley. I'm gonna disconnect you, or you already did. You actually knew how to. Okay, so this is in the matter of the people of the state of Michigan versus Kelly Margaret Mahoney, file number 24-21862FH. So Mr. Fry represents Ms. Mahoney and Mr. Sneed on behalf of the people. All right, so I have a letter from July. She's got cases. Kalamazoo County, Jackson County both have warrants for arrest. Okay, so she's in Jackson County, so I guess we need to set another date and get a writ.
Well, Your Honor, my understanding from my last conversation with her is that her out date in Jackson County is November 4th. So she'll probably be out by the time we get back here, I'm assuming.
Okay, but I'm gonna put a holder on her, so let me see.
Yeah, so she might be brought here.
So she's got, Miss Adams, I'm looking at her paperwork and it looks like she's got a PR bond, is that correct? July 8th paperwork shows a PR bond. I want to put a bond on her just to snag her.
My understanding is we changed it at the last hearing and you put a $500 bond on the case.
Well,
Last
Got
night's
my-
is a pretrial release on July 10th.
and what is the bond?
A PR bond.
So I'm gonna set bond in the amount of 10,000 cash just to get her here, and then we can address bond. So I'm gonna revoke her PR bond and set a 10,000 cash bond. She scored incredibly 7 on her assessment, risk assessment. So I'm gonna set a pretrial conference for, I'm gonna do November 13 at 8:30.
Your Honor, I am out on vacation that week.
Good for you. How about November 20th?
Yeah, I can do that.
Okay, so we'll set up for November 20th at 8:30 in the morning. All right, so is there, I don't see anything else. So in the matter of the people of the state of Michigan versus Zachary Allen Davis, file number 24-22014 and 15, Mr. Glazier waived arraignment on that one. So I think this concludes our criminal docket. Mr. Sneed, thank you. Thanks, Miss Holly.
Thank you, Judge.
Fonseca, no, he waived.
Yep, he waived.
Okay, all right, thank you.
All right, thank you.
Thank you.
Bye-bye.